All right, let's jump right into it. Today, I'm going to talk about protecting your legacy with estate planning. So, this comes up quite frequently because there's lots of questions around, are there specific things that I can do? I'm concerned about long term care, if I need to go into a nursing home. And I find that to understand how all of this works, we really need to take it back to the basics to begin with by talking about one, what is an estate plan? Because we've got to understand why you would have one to understand how it could protect your assets ultimately. So, an estate plan really is having the documents and legal documentation in place to help protect you and your assets. So, this is either a will, this could be a trust, whether it's revocable, irrevocable. It could be having a simple estate affidavit that is legal in the state of Idaho. It's just a little tricky because you have to have assets under $150,000. Another big part of the estate plan is having a financial healthcare power of attorney. So, those power of attorney documents. I will get into those specifically and what each one of those means. But the probably the fourth part that would be quite crucial to an estate plan in today, for now, is having a letter of direction. And that's because it gives very specific instruction as to what you want carried out. And I'll kind of touch as to why that plays such a big part. So I want to start by jumping into, I have probably helped a lot of you or talked with a lot of you. And if I haven't, I think it's super crucial to understand the biggest differences between what is a will, what's a trust, what they do for your estate, and what they ultimately mean. So with a will, it establishes an executor. So an executor meaning this is the person that you name once you or your spouse have passed, that they're going to be in charge of passing out your assets, disseminating your assets essentially. So the other part to a will, you name your beneficiaries. So you'll typically list out like, here's my living issue, as it's called, meaning like, here's my children, here are my spouses, or like ex-spouses can be listed too as well. But really the intent would be like, I'm going to list who will be the recipients of my estate. And that's usually done in percentages. So it'll just simply state like, these are my children at the time of my passing. You would list out any that had passed away prior to your passing or the reading of the will. But essentially, it's just the percentage of, 25% is going to go to each one of my four children. That's really all you do with beneficiaries in the will. The ultimate goal of the will is just the division of assets. So it's really just to say like, okay, I'm splitting it out. I'm giving it away. This is who I want to have receive it. It doesn't create any other like sub trusts or anything like that. It just essentially says, this is where my stuff is supposed to go. And nowadays it's done very cleanly, meaning like it really is just like, take all of my assets, divide it into the percentages that I have listed out here, and give that and pay it out according to those beneficiaries that I've listed. So from that standpoint, it's changed a lot because wills used to be very, very specific with listing out individual items. So this heirloom goes to this family member, this item goes to this family member, and that still can happen, and that is done through a bequest. So a bequest is something that's unalterable through any part of the process. It is no matter what needs to be carried out. But because of that unalterable nature, it's gotten to the point where attorneys and lawyers prefer to actually just list out the percentage of the estate that goes to a beneficiary, and then they leave the specifics to the letter of direction. And the reason for that is that letter of direction allows you to make changes to those specific items without having to amend the will. You don't have to go and visit them, sit down, pay, anywhere from $300 to $600 an hour to have just a small, simple change and have everything recreated to if someone ticks you off and it's like, I don't want them to get that as part of the will anymore. That's the reason why the letter of direction has become so important, and it doesn't have to be notarized. So the changes can be done at your discretion and when you want to without having to make a visit. So, but if you do have those specific items where you're like, absolutely, no matter what, I want this particular item in my estate to go to this neighbor, to a friend, to a charity, or a child, you can do it through the means of a bequest. So you do still have that option. Another purpose of the will is to specifically disinherit individuals. So I typically see this when clients have been previously married and they want to list out an ex-spouse. They do this so that after their passing, an ex wouldn't be able to come forth and say, you know what, actually, I was entitled to some of this estate. This is one of those ways that you can make perfectly clear they're cut out. There's nothing that they'll get. I've also seen some clients do this with children that are estranged, where the children have nothing to do with them, and as a result, they say, you know what, I want this child cut out of my will. So it's just another tool for you to be very specific with what your wishes are. So the other part of the process with a will that you need to know about is, even if you've done everything properly with your will and spelled out exactly who should get what, a will still has to go through the probate process. Now, the probate process is where you actually have to either hire an attorney or be savvy enough with the law to file a motion with the court stating, and this is done by your executor, that the estate owner has passed. And now we're entering the probate process, where a judge ultimately reviews the will, whether there's a will that exists, or if you die intestate without a will, then the judge will be responsible for naming who will be the acting executor and how the assets should be split out. But if you do have a will in place, the probate process it goes quite simple, but essentially it's where all of your assets are put on public display, and the public has to have knowledge of the passing, so that if there are any uncollected debts or liens or anything out there, it gives an opportunity for members of the public to lay a claim against the estate before it can be closed up. So it becomes a very public process of everything that you've got. The other part about a will that's interesting is it's supposed to be something very immediate. So that means as soon as the passing of the estate owner occurs and there's a death certificate, the executor who's responsible for stepping up, it's their job to act in a timely manner as quickly as possible. You're still subject to the probate process, which in Idaho, it's not as expensive as other states. And luckily our court system isn't as backed up. So you're able to get through that roughly, I've seen it done as quickly as 30 days, but sometimes it can take up to 6 months, just depending on the size of the estate and all of the assets that have to be worked through. The will, the other part that I should mention real quick too, before chatting about trust, is that in the state of Idaho, and actually anywhere, a couple should each individually have their own will. So for a long time, it was common practice to have a will that listed both of the spouses at the same time. It's better to have individual ones, because when one passes, the will, if you share a will, it needs to execute at that time. And if it executes, it will leave the second person in that will listed unprotected. They would be responsible for going and getting another one to have their wishes carried out. So from that standpoint, just know having individual wills is helpful and important. Okay, now let's jump into trust. So one of the biggest things that separates a trust from a will is it creates an entity. So when they're created, they can be created under one of the trustee or you yourself's social security number, but upon your passing, your successor trustee, who is responsible for stepping up and actually organizing, handing out the assets, going through the process, they will have to file for their own TIN, tax identification number. So it creates I like to refer to it as kind of a box. And what a trust does is it gathers all of your assets and dumps it into that box. And the trustee gets to decide at what time is best for the beneficiaries to pull those items out of the box and to realize any like capital gains that might be due or taxes that are due. The other thing that the trust does is the trust, because it's an entity, it can actually handle and pay for the taxes instead of making the beneficiaries responsible for that. So that's another benefit for why you might consider using a trust in your estate planning. A trust, like a will, also lists out beneficiaries. They're typically done in percentages as well. So again, to explain this, this is like taking your entire estate, all of your assets, and saying, if I had 4 children, I want 25% to go to each one. You don't, in the trust, necessarily spell out all of the specifics unless you go through the bequest section where you say, I've got this one item that is absolutely crucial and I will not change my mind about it. This absolutely has to go to this person. So that is an option to have that. The goal is just the division of assets with the trust. As I was stating, where you create this box to hold everything, you have more timing around it. You can handle the bequest, like I mentioned. Trust also can do the disinheriting of individuals, where you might list out a child or an ex-spouse where you want them to have nothing to do with the trust or receive any of your assets. Another one of the perks to having a trust is there's no probate process required. So if you have properly titled all of your assets, if you have funded the trust properly, there will be no reason that the court has to be involved, that a judge will have to step in and list out how or like what will who will get what, who will be responsible for any part of it, which is nice. I see that as a big perk, just because also it means that you're able to keep your assets private through that. And then I already mentioned this one a little bit, but again, there's no time frame on trust. Trusts, they don't have a death date. They do have a creation date, but there isn't you have to wrap it up by this amount of time. There isn't as much pressure like a will to wrap it up as quickly as possible. You could have a trust exist for decades, indefinitely, essentially, if there was grandchildren involved or great-grandchildren that could benefit from the assets that were held inside of a trust. So they can be closed out when they're officially done and everything has been disseminated, but until that point, they have the ability to exist. One other thing that I would tell you real quickly between the difference of wills and trusts tend to be more expensive. And that's just because there's more creation involved as far as how much work goes into the creation of that entity that backs the entire trust. Then there's the process of funding the trust, which usually requires like the proper titling of assets and knowing which assets need to be included in the trust. And that's important to know about, because not everything gets dumped into the trust, specifically like retirement accounts. I kind of had mentioned there's no death date to a trust. And so if you were to leave a traditional IRA to the trust account, what's tough is they don't know how to calculate required minimum distributions because there isn't a death date. So as a result, they want you to pay all of the taxes up front before you're able to give any money out of the trust of the retirement account. And when you do that, the taxation could be, you could hit the top tax bracket just because of all of the funds in that retirement account, depending on its size. So that's one of those reasons where you need to make sure that you understand the different types of accounts that need to be held in the trust. The taxes, again, big part of understanding how that works. So that's the difference between wills and trusts. But that other part of the estate plan that's crucial to understand are the powers of attorney. So I had briefly mentioned you need a healthcare power of attorney and a financial power of attorney. The reason why we see a split or a division between the two is because there used to be what's called, and some of you still might have this, a durable power of attorney or a general power of attorney. And that was the intent that you just named one individual to handle all facets or areas of your life. And that's fine. But what we found, and I've seen this for a lot of clients, maybe the child that's really compassionate and would be super great with healthcare isn't the most money savvy. And so by having a healthcare versus a financial power of attorney really allows you to pinpoint the individual in your life or child or beneficiary that would best be suited to help make those decisions. So the other part about a power of attorney in your estate plan that is super important to understand is your power of attorney only has power or the ability to act in your behalf while you're alive. So there's a lot of confusion around this because I've met with a lot of clients that are like, oh yeah, I'm not worried about a will or a trust because I have a general power of attorney. And this is kind of a misnomer again, because once you pass, the power of attorney is null and void. They have no more ability to act on your behalf. So it used to be too that power of attorneys only were available to work or operate after you'd been declared incompetent. And your general power of attorney or financial or healthcare power of attorney will spell out its terms. So for instance, some will state, this is not active until I have been declared incompetent by 3 doctors. And then you have to provide all of that documentation. So others, they have a different setup where it's immediately upon signing. What's interesting is we have found more recently that it's almost impossible for a doctor to be willing to take on the responsibility of declaring someone incompetent. So just depending on what your setup is, it's important to understand, do I have a power of attorney that's active currently? So if I was in a car accident and laid up in the hospital and my wife needed to be able to step in and sign documents on my behalf or write checks, pay bills, am I going to have to be declared incompetent by 3 separate doctors, or is it power that's available immediately? And that brings up another point, like you want to make sure you can trust them fully, because your power of attorney documentation will list out all of the powers that they can execute, all of the rights and privileges that you're granting them. So we've been in situations where beneficiaries needed to be changed, and the power of attorney documents did not allow the power of attorney to do that. So it's just something where you need to make sure that the wishes or abilities, powers that you want to grant are listed out. You need to understand how they work, and you need to understand they're only good while you're alive. The minute you pass, your power of attorney has no ability to act on your behalf to disseminate your estate or to even do anything else in your name or in your behalf under that power of attorney document. Okay, so super important. I tell clients that if you are hesitant or not really sure where to start with estate planning, I like to start with those power of attorney documents, because we've actually seen, and this has happened with a previous client, the client was involved in an accident and they were laid up, and the client was divorced, so the spouse was out of the picture, but the children had to go and seek guardianship with the state to be able to take care of their parent. And it was this long drawn out process because it took several thousands of dollars and several months to get approval for guardianship. And it kind of left this client in a limbo situation with no one to be able to take care of them. So that's why my personal starting point for an estate plan is, if you don't know about a will or a trust, start with those power of attorney documents to make sure that you're set and at least protected. Because if you were to pass away and you didn't have all of the estate done, meaning a will or a trust in place, there's the probate process for a judge to decide for you, and they will clean up the pieces. They will sort it all out. But if something happens to you where you're still alive but incapacitated, the process that you'll put someone else through, it's lengthy and it costs a lot. So just a pro tip there to help make it a little bit easier. So this kind of takes us back to protecting my assets. So what do I do? Because this question comes up a lot. I'm concerned about, if I were to go into a home, I've got more assets than what's allowed by Medicaid. So can they seize my assets? What do I need to do? And so I have a lot of people ask, well, a trust, I've heard a trust. It's true that a trust can protect your assets if you use an irrevocable trust. The catch is, and irrevocable just means that there's absolutely zero changes that you can make to it once you've made it official. Once it's notarized and you've laid it all out, there's no changes that can be made. But that isn't enough. not only does it have to be irrevocable during your lifetime, but you cannot be the trustee of the trust. You have to completely separate yourself from ownership, and that has to happen for a period of 5 years. So if you're looking for the state or government assistance to help pay for nursing home or care after you've personally spent money without them trying to attach to assets, which they can, there's this 60-month look back period. And so if you're trying to use a trust, you cannot be a trustee of the trust. You have to name someone else entirely, and you have to clear that 60-month or 5-year period of time. Because if something happened in 2 years into this irrevocable trust where you named maybe a child as the trustee of the trust, if that happened like 2 years into it and you were trying to apply for Medicaid, they could look back on this and say, you haven't cleared that 60-month period of time, and they could use assets or require assets of yours to be used to help pay your bill. So wills do not have the ability to avoid this. If you do a revocable trust, which is the most common usage of trust, a revocable trust just means you can make changes of the trust during your lifetime. You're also typically named as trustee of it. So a revocable trust, for example, if I opened one, this would be one with my wife and I as trustees, and then we would choose successor trustees to replace us after we passed. But that would grant me and my wife the ability to make changes to the trust at any point until both of us passed. Once we have both passed, then our successor trustees do not have the ability to change any of our wishes at that time. However, this doesn't do anything to help protect us against needing future care or long-term care, any assisted nursing facility needs. Really, it becomes tricky because this whole part of protecting your assets is understanding you really have to separate yourself from your asset for at least 5 years to help avoid this. Just know too that if you were to go into a home and you still had a spouse living at home, they cannot sell your home or seize your home with a spouse living in your house. They do not have the ability to kick you out. So there are some things like that to help protect you through that. However, one of the biggest things that you can do is just making sure that you have properly titled your accounts and your beneficiaries. So I've seen this to be one of the most helpful things. You can go through all of this process of creating wills and trusts or documentation, but if there are some accounts, like specifically accounts directly with institutions like a Schwab investment account, or maybe it's an annuity with Allianz, or any different issuer, they have specific forms for beneficiaries of the accounts. And this applies to bank accounts as well. So one of the biggest and best things that you can do is make sure on those accounts that will not be listed specifically in a trust or an asset that's going to be titled in a will, you just need to make sure, do I have proper beneficiaries listed on this account? And, one quick, I just recently had a situation with a client where we went through the whole process of creating a trust, and I made sure that in the assisting process of being like, we need to know about everything as we work with the attorney so we can make sure everything's properly titled. And inadvertently, they had omitted this CD that they had recently purchased that was paying 5%. And what was tough is through that process, they did not put a beneficiary on file. And so even though they had a trust in place and everything that was supposed to scoop up the assets and dump it into this entity for a trust for the successor trustee to give away, when this client ultimately passed away, the successor trustee was like, I've provided all the documentation to this bank for this CD, but because we didn't have a beneficiary on file, that one specific account had to go through the probate process for the judge to read the trust, read the wills that were part of the trust to determine who should get the money inside of that CD. And that all could have been avoided if we had known about it, to know like, oh, okay, yes, specifically we need to make the beneficiary of that account the trust. And then the trust can use its specifics to disseminate those funds to the right people. So just a real experience that we've had where that's massive. I want to talk about, again, real briefly, letter of direction. So because this is where you list out the specifics of, I want my wedding ring to go here. I want this vehicle to be sold at fair market value to one of my children. I want, here's a family heirloom and this is who I want to have it. And this is why it's so important to us. The letter of direction is a separate either letter. I like to prepare it in a book, but it's something that accompanies your will or your trust that gives out specific direction. And again, it doesn't have to be amended if you change your mind. And that's what's so great about it. The letter of direction is also most so similar to what people equate the reading of the will. So a lot of people are like, well, when do we read the will? When do we read the trust? And what's interesting is the actual will or the trust would bore anyone to death in a matter of seconds because there's nothing typically exciting in it. It's usually just the biggest listing of here's all the powers that the executor or trustee has, not the specifics of this is what I want Susie to have and Sally gets this. That happens in a letter of direction. So one of my biggest tips is make sure that if you have your estate planning done and you have a will or a trust that references your letter of direction, sometimes it's called a letter of instruction, that you actually complete it, because that letter of direction is what will make it more simple and more easy and more clear for the surviving beneficiaries to split up your assets the way that you wanted it to. Okay, next pro tip. With your bank account, it's essential that your account, all of your accounts have a beneficiary. If you don't use a trust where we would actually title some of the accounts to have or be titled into the trust, again, like a bank account, like your checking account that you use now, I recommend getting an account signer. So what you do is whoever you would trust, this might be your financial power of attorney, this could be your successor trustee, take them to the bank and add them with a signer card. So you're not adding them as a joint owner. That would add too much legality around, like if they had trouble with like a bankruptcy or a car accident and they were trying to seize assets, they would see that asset that you would name them with if you put them on as a joint owner. So just adding them as an account signer, you don't redo your checks. It doesn't retitle the account. It just would give them the ability for this period of time between when you pass and when they would be able to get a death certificate for them to continue to use funds out of the account. So this, I've seen this work personally within my own family where I waited for 3 weeks for a death certificate to show up for a family member, but this allowed me to be able to write checks to pay for the funeral and the flowers and the luncheon that happened later without having to shut down the account or having any trouble at all with the flow of money. So this was, again, you do this by taking the person with you. They'll have to prove ID at the bank or credit union, wherever you bank, but you just add them as an additional account signer. And then they keep a signature card on file. Again, you don't have to have your checks redone or anything like that. It just allows for someone else to have access to your money. It kind of works like a financial power of attorney, but this is something that will allow that ability for them to sign on the account beyond your passing. Because if you're doing it under a financial power of attorney document, upon that person's death, they no longer have the ability to sign those checks. But if they're an account signer, this would allow that to continue. Okay, another tip is I would keep a digital copy of those power of attorney documents and even the trust or will. We live in a digital age. If you have children that would be that financial or healthcare power of attorney and they're going to travel to you, if you ended up in the hospital, it'd be really convenient for them to have access to it electronically on their phone without having to go to your house and try to dig up these documents. So knowing how to access a digital copy or getting a digital copy of it is a really great resource in making it easier. Okay, titling is another great tip. I've kind of mentioned this throughout, but it's understanding what kind of accounts need to have the right kind of titling. Like when you have a trust, to fund the trust, you will actually move your homes into the trust. So you will do either a quitclaim deed or some kind of titling deed with the county to put your home into the trust. But let's say you don't go with a trust and you're just going to use a will. It's important for couples to make sure that both of you are listed on the title. I can't tell you how many times in going through the estate planning process and helping out with it that we have seen just one of the two spouses listed on the title. And sometimes it's an error in how that was filed. Sometimes it was a mistake because of the lender. It's just a double check, and it's worth having it done and handled before it's too late and finding out like now we really have to use the probate process to get this straightened out by a judge. So definitely something to check into. The other thing is just a regular review. I think one of the most important things you can do is understand what you have when it comes to estate planning. Does it need to be updated? Has there been a death? Has there been a marriage? Has there been a legal name change that needs to be updated? It's such a hard time after someone passes. And it's crazy because you go through all this work with the estate plan and then it's handed over to someone to carry out your wishes. And you'll find that there's so much that maybe you didn't prepare for. If you've ever been in that position as an executor or a trustee, you didn't ask all the questions that you would have liked to have to know how to handle things. The more that you can do personally as the creator of your estate plan, the easier it will be for the person that has to step into that role. And then the more fully your wishes can be carried out. From that standpoint, a regular review, and I would do it with your bank. I would do it with the accounts that you have at the bank, any financial advisors, anyone that you're working with. It's just smart. I don't ever want anyone to be in a situation where maybe you add an account later in life, like I did with this client, and now the successor trustee had to go through probate just because of mere oversight, when it would have been as simple as like, oh, I just need to put the trust as the beneficiary of this CD if something should happen to me. So regular review is really going to be the wrap-up tip, because checking in and making sure that it's done, getting legal advice, super important, and making sure that you're taken care of. That is going to be the biggest way to protect your assets. I have to give you my disclaimer. I do not have a Juris Doctorate, but what we have done at Journey Financial is we have built a network of attorneys that allows us to help you get this estate planning done at a fraction of the cost that they charge if you try to do it here locally or in any of their offices. But I've seen the work that our attorneys do stand up with from a nationwide standpoint, and it's phenomenal. And I've heard feedback from local attorneys too that the work that our attorneys do is great. I bring that up because we really just want everyone to have the protection in place. Just know we're here to answer any questions. Appreciate your time. Thanks for hanging in there with me, and I hope you have a great day. Thanks.